Hey, Ultra Legal Warriors. In this video, I'm going to cover one of the biggest misconceptions we hear in the criminal defense world. We get a call from a potential client on the phone, and they say, hey, I've got nothing to worry about because there is no evidence against me. There's never such thing as no evidence against me, and I'm going to cover why that is in this video. If you're interested in this area of law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. What is a misconception? We get a call on the phone, someone comes into the office, or we even have a current client who says, well, Lance, how could they prosecute me? There's no evidence against me. We hear that for crimes, we hear that for protection orders, and it makes sense. When we think about evidence, when we all watch true crime and watch our TV shows or movies, we think about DNA, fingerprints, eyewitnesses, text messages, things like that, right? We think about that as evidence, like Sherlock Holmes looking for evidence. And our brains, we naturally, if we're accused of a crime, we want to try to, think in opposition of that. We want to try to save ourselves from the problem. And so we can delude ourselves in saying, but Lance, there's no evidence against me. And let me tell you what most evidence is in all criminal cases is just one person say so, right? It's just one person say so. In a typical case where an officer gets called about a dispute at a family home, they'll show up and someone's called the police and one partner says he or she shoved me and the other partner says, no, I didn't. And guess what? With a shove, there's no physical evidence. There's no bruising typically with the shove. There's not going to often be torn clothing. There's not going to be a video typically in the household. Yet 9 times out of 10, the person who is accused of doing the shoving gets arrested. Why? Because the evidence is the other person say so. The other person say so is evidence. It's the only evidence oftentimes that law enforcement has to consider, right? So in that case, the officer comes, they make a judgment call based upon their own credibility determination. Hey, is one person upset? Is one person crying? Is one person mean sounding and elevated? Why would this person call the police if it wasn't true? And the evidence they rely on is their own visual of what visuals or stuff and audible listening and their own opinion. And so that evidence that led to someone's arrest is that person say so. And the system treats that as evidence. That's why I'm making this video. Don't think that the system doesn't treat that as evidence. It is, and it does, and it's often the only evidence that the system even has to consider. And guess what? Plenty of people are convicted on that type of evidence because our jury system is a bit of a falsehood, in my opinion, because it's sort of set up where it's all this bad stuff is said about a defendant and all this jury is sort of ganging up even more and more, right? Tribalism versus that outcasted defendant. It's set up for them to believe that type of evidence, right? What's some other cases where a client might say, but there's no evidence against me, and the evidence is typically just one person's word? Well, it might be a theft case, right? It might be a theft case where someone takes off on something at a store and they aren't caught. And then there's a claim that, hey, I saw that person take something. And oftentimes the video is not good enough to say so, right? And we don't recover the product. The product's missing. Well, the officer very well may believe that store personnel's eyewitness say so, that is the evidence enough to end up arresting somebody and charging them with the crime. And I'm making this video so if you're out there and you're believing nothing can happen to you because there's no evidence against me, and therefore you're not going to take the situation seriously, I don't want you to think like that, because the large majority of the cases, the only evidence is someone say so. Let's hope you're never accused of a crime from a long time ago, a sexual crime from a long time ago versus an adult or God forbid, versus a child, and you're accused of that and you're innocent, right? Oftentimes those accusations are 4 years, 5 years, 20 years old. And we'll hear people on the phone, well, how could they do anything to me? There's no evidence. Well, the system doesn't think like that. The system would think there's never any evidence of certain types of crimes. If they're old crimes against children, typically don't have evidence because they take a long time to report. Sexual crimes may have no evidence because they take a long time to report, and therefore any physical evidence that did exist is gone. And routinely, those cases are followed up on, prosecuted, and people can actually be convicted. And there's plenty sitting in prison right now where the only evidence was someone's say so, not a DNA kit, not a rape kit, not fingerprints, not another eyewitness, not an admission by the suspect, nothing except a prosecutor and law enforcement chose to believe them. Right? That's the type of system that we're working in. And it's so random about what someone will believe versus what someone won't believe. So how do you deal with it, right? How, Lance, do you deal with a situation where someone's say-so can be enough to get me in trouble? Well, what we have to do is build our own case about our say-so, right? Our say-so needs to be more credible than their say-so, right? What reason would they have to lie, right? And, why would they claim that you pushed them when they didn't, right? Is there a history of false allegations? Were they drunk and you were sober, right? Are they the one with the anger problem? If you're accused of a crime that happened a while ago, where were we, right? Do we have an alibi? Were we even in the state, right? Were we at work during this? Those type of things. We want to make our say-so more credible than their say-so, or at least we want to be able to discredit their say-so if all they have is what they are claiming and there's nothing else to support what they're claiming. But please disabuse yourself of the notion that just because they're saying it and there's nothing else, that's not evidence. So that's strong, compelling evidence to the system. That's almost all we ever have. It applies for protection orders. Also, every protection order case, you're going to see the most of the evidence that's out there is just someone writing it down. That's the evidence. And God forbid if you expect the court to hold the line against that type of evidence, because let me tell you, most courts won't. So this is not to ruin your day. This is not to ruin your life. This is to make sure you take things seriously. Please understand that evidence does include and almost always it will involve heavy reliance on one person's say-so as the primary or sometimes only evidence in the case. So take that seriously. Get some help, protect yourself, and hopefully you won't end up on the wrong side of a wrongful conviction. So if you found this useful, I hope you did. Please like and please subscribe. More people get the help they need. More importantly, if you've got a legal problem in Washington State, a crime or a protection order, we do those too. Feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.